I'm a dual qualified lawyer with over 17 years experience in corporate and commercial. My focus is M&A transactions, and I've completed somewhere over 50 of these. I'm currently working as a partner of Gunnar Cook LLP, and not at last, I've been working with BCMS family companies, including Kingsbrook, in the last 12 years. So I would say that the most important thing the business owners need to bear in mind when planning an exit is get ready for the sale. And getting ready for the sale means preparation. It's like when you take your car for your annual MOT test, the car is running smoothly and it's all good and you think you'll just go, and suddenly the test result comes out with some issues. It's the same with the legal preparation for the sale. It's better to get legal tests done early rather than let the buyer run these tests for you if you want a smooth completion. Should you not do a legal preparation, things can get really difficult and there is no good news whatsoever. So this can lead to the deal to fall over altogether because the problem cannot be resolved, because it's too late and will take too long to be resolved, or the buyer's concern is so high and the buyer and the sellers cannot reach a compromise in relation to a particular issue. So altogether the deal may fall, but it may also lead to very, very long delays. And even after these long delays, there may be no successful resolution to it. Right, this is an important question. It depends from what direction you are looking at. If it is related to the buyer, probably the main issue would be raising the money for funding the transaction. If it relates to the seller, it's probably something which it may come up during the buyer's due diligence process, an issue or issues which may concern the buyer and the problem cannot be resolved, or a compromise cannot be reached between buyer and the sellers. Let me give you an example about a seller issue. For example, the company has done in the past a share buyback, a purchase of its own shares, and this hasn't been done properly. Unfortunately, this hasn't come up until the buyer's due diligence, and the consequence of that is that the shares weren't actually cancelled, and the old shareholder, the previous shareholder, was still a shareholder of the company, and that complicated things thoroughly and led, for example, in this particular case, to fail the deal. Another example, and this can be now, this is slightly becoming out of date now because HMRC is getting heavy on resolving these situations, is the issue of employee benefit trust. This has been picked up during the preparation for the sale, so during the preliminary due diligence undertaken by the legal team. And because this has been done, a settlement has been reached with HMRC, and this wasn't a liability concern anymore for the buyer. So by the time the client had an offer from the buyer, the HMRC issue has been resolved and the deal could be completed. Otherwise, could have led to no completion whatsoever, or a delay of 6 to 12 months, and the buyer may have lost interest altogether. Just thinking about one which can be quite a popular finding, most of the companies would have also minority shareholders and have articles of association which go back to 1985 or even earlier. And because there was no concern to update them whatsoever, when the sale came there was no drag and tag along provisions in the articles, which meant that the minority shareholders could create problems. We identified this issue in the preliminary due diligence, and we amended the Articles of Association, and this led to a smooth completion with no problems from the minority shareholders whatsoever. One of the most interesting things is people are still not understanding what statutory books are and why they are important. And this is suddenly becoming really important at the point of sale, because it is not the confirmation statement which you file at Companies House showing the title of shares. The title of shares is proven by the share certificate and the statutory books, which show the history of the share transactions from incorporation. And any buyer would be interested to check these documents. And usually this comes out very easily during the buyer due diligence process and delays the process, because they need to be reconstructed because they have never been kept. So we had a few situations like that where we identified early stage that the statutory books weren't in place, up to date, or needed to be reconstructed altogether, and we've done that. So when it came to proof of title of shares, there was no issue whatsoever. So one of the most important aspects, which usually owners would not think about until the buyer's due diligence process starts, is their own contracts. And it is important that at early stage it is identified if these contracts have change of control clauses. To give you an example, during one of our preliminary due diligence exercises, we identified that the client had about 3 contracts, with all of them would have change of control clauses, meaning that there was no flexibility whatsoever. So the client would be forced to terminate the contractual relationship if there was a change of control. There wasn't even a consent element in there. And by identifying this at early stage, it helped the client to start manage the customers, and he was lucky because one of the contracts was close to renewal. So when he renewed the contract, he made sure that the change of control was more flexible, asking for consent rather than terminating the contract straight away. But the client was aware, was prepared, and started to manage customers' expectations in relation to a potential exit. So it was great help for the client, and no problems at completion. Most of the transactions will not just have a simple completion money. There will be always an adjuster element, or they call it adjustment tool. And this is actually either having a net asset value target or a working capital target. Most of the transaction would go probably for net asset target, but it really depends on each individual transaction and what the buyer's expectations are. But one thing which is important, and it happened before, is the value of the stock. Because the way the business values its stock, it can be completely different the way the buyer would look at it. And this situation would constitute most of the time a reason for conflict between buyer and the seller when agreeing the completion accounts post-completion of the transaction. So it is very important to look at the stock value and to apply the right principles if you are planning for an exit. As you probably are aware, most of the businesses would have loans. Loans owned by the company to its directors, or loans owned by directors to the company, or intra-group company loans. But what is important about that is, if you are planning an exit, you need to be aware that a buyer would expect these loans to be paid on completion. So it is likely that the completion money would be used for paying these loans unless you prepare and plan ahead and you start paying for these in advance. But it is important to understand what this means for your business and for yourself if you're planning an exit. So why is to do your legal tests better than leave the buyer to run it for you? Is because you get ready and you will know, you will understand your business better, and if there are any issues, they can be resolved. One of the most overlooked area in the sale process and preparation for the sale process is the legal preparation. And we have a great product. It's a legal review which would take you through all the areas where a buyer would be looking. It's not as thorough as the buyer's due diligence, but it's thorough enough to identify any red flag issues. So you would be able in this respect to resolve them at early stage or understand what they mean and how they can be dealt with when negotiating with the buyer. It may look a bit scary because it covers about 15 sections with 55 areas. Looks like a lot, but it's not, because it's built in such a way to take in consideration that you also need to run a business. So most of the work will be done by your legal advisor. And you need to have a good one, of course, to do that, because you want to work with the best. If you're interested, our details are at the end of the video. Please do get in touch.